Morning and welcome back to Legally Married, Legally Raven here, and we are continuing to read about the Schulansky case in chapter 29 of Joseph Glennon's examples and explanations. So let's go ahead and get started. I'll try to finish reading this chapter today. So really excited about that. A little tired. My little furniture is finishing and turning some things around over here. So just a little tired. That's all. Okay. Let me see. Making an awful move. Okay. So we didn't read much. Yeah, we just talked about preparing for filing the suit. Okay. So we're going to start drafting the complaint. I'm gonna plug the computer because I don't want it to fall. So it's story time. Alrighty. Drafting the complaint. Assuming that informal settlement efforts fail and the plaintiff's attorney concludes that it makes sense to file suit on a claim, she will bring the lawsuit by filing a claim, the first pleading required under the federal rules and many similar state rules. Pleadings are the papers filed by the parties at the beginning of an action in which they set forth their positions as to the facts in the issue. Pleadings are not evidence. They are not even sworn testimony by the parties or their attorneys. They are simply statements of the parties' positions on the factual and legal issues in dispute. In the simplest two-party suit, the only pleadings required will be complaint, in which the plaintiff sets forth her claim, and an answer in which the defendant responds by stating her position as to each of the allegations in the complaint and asserting any other defenses she may have to the plaintiff's claim. See the plaintiff's complaint in the Schulansky case and for page 574. And Ronan's answer for page 604. But further pleadings may be necessary if additional parties are brought into the suit or if counterclaims are asserted. See Chapter 33, which includes a third-party complaint. See also Federal Procedure 7A, which describes the various proceedings that may be filed in appropriate circumstances. Both the form and the content of the complaint are governed by the rules of procedure applicable in the court where the suit is filed. Because the Schulansky case was filed in Massachusetts Superior Court, it must comply with the Massachusetts Rule of Civil Procedures, which quite similar to the federal rules. Chapter 30 illustrates in detail how the complaint was drafted to comply with those rules. In addition, most courts have local rules of procedure that supplement the general civil rules. For example, the Massachusetts Superior Court has its own supplementary rules that cover numerous details of practice before the court. Thus, all applicable local rules must be checked in order to comply with any additional requirements. In drafting the complaint, counsel must also consider whether the procedure rules allow joinder and all the desired parties as plaintiffs or defendants. The joinder rules are analyzed Chapter 13 to 16. The substantive law governing the plaintiff's claim must be analyzed to ascertain whether there is good ground to file a suit on the claims asserted in the complaint. A large part of the attorney's memo in the following chapters is devoted to considering whether law of contracts and negligence will support the claims for relief in the Schulansky case, and if so, how those claims should be asserted in the pleadings. Tactical considerations in choosing the form. The plaintiff's counsel faces a number of real-world tactical issues when deciding where to bring a suit. To begin with, she must choose a court that has subject matter jurisdiction, personal jurisdiction over the defendant, and satisfies the applicable rules of venue. See Part 1 for a detailed analysis of those requirements. It may not always be clear from the facts whether jurisdiction and venue are proper in a particular court. In Shulansky, for example, there is some doubt as to whether the Massachusetts court has personal jurisdiction over the defendants. If so, the attorney will have to make a judgment as to whether the advantages of litigating in her chosen form are outweighed by the risk that the suit will be dismissed on one of these grounds, causing additional expense to the client and possible statute of limitation problems. The plaintiff's counsel must also decide whether to file suit in federal or state court, assuming, as it will frequently be the case, that jurisdiction and venue are satisfied in both. Numerous factors may be important in making that choice. For example, the scope of pretrial discovery may be broader in federal court. Federal courts also have broader powers to transfer cases than do state courts. On the other hand, the scope of interlocutory review may be broader in the state court than in the federal court. See Chapter 3, Example 9, considering interlocutory appeal of decisions on motion to dismiss for lack of personal jurisdiction. The right to join additional parties may differ, as may the court's power to exercise personal jurisdiction over them. Differences involving the trial process itself may also be important in the case. For example, the rules of evidence in the case, the rules of evidence in the state and federal courts may differ in crucial respects. The power of court to subpoena witnesses will differ. The ethnic and economic characteristics of the jury will differ because a federal court jury will be drawn from a broader geographic area. The judges in one system may be more familiar with the type of case or suit, and may be possible to get a trial a good deal more quickly in one system than the other, or in one state than another. Convenience may also play a role in the decision. The plaintiff's lawyer may be familiar with the practice in one system. One court may be conveniently located for the plaintiff or her attorney, or more inconvenient for the defendant or her attorney. Attorney Slater's initial memo in the Schulansky case does not reveal all the factors she considered in deciding to go to state court, but proximity to her client's home and her office were undoubtedly an important one in which a relatively small case, innumerable other such factors may be significant in a particular case. For more detailed discussion of the tactical reasons for choosing state or federal court, see S. Stained Glass, the Emerging State Court, Section 1983, Action, a Procedural Review from the University of Miami Law Review in 1984. All right, now we're going to talk about filing the complaint. Okay, I forgot I was supposed to sit in front of the light. So here I am. Okay, great. Now, let's talk about finding the complaint. In view of all these considerations, the attorney will draft the complaint, file it with the clerk of the appropriate court, and serve it to the defendant. As to the proper method of service, see Chapter 17. If the defendant is already represented by counsel, the plaintiff's lawyer may, as a matter of courtesy, call the defendant's lawyer to let her know that the suit is being filed. In turn, the defendant's counsel may agree to accept service of the complaint and summons without compliance with the formal service rules. It is only upon the filing of the complaint that the court gets involved in the case. At least initially, its involvement will be minimal. The clerk will assign a docket number to the case and establish a case file. All subsequent pleadings and other papers filed in the case will be docketed. That is, entered on a docket sheet kept with the case file and added to the file. Not surprisingly, case dockets are increasingly computerized, and many courts are experimenting with electronic access to court records and electronic filing of pleadings and other papers. In federal court, the case will usually be assigned to a judge when the complaint is filed, and the judge will then preside over the case for the duration. In some state courts, however, the case is not permanently assigned. Different proceedings will be heard by different judges depending on which judge is sitting at the time a motion comes up for hearing or when the case reached the trial list. For example, in the Schulansky case, if the Schulansky case had remained in a Massachusetts state court, the motion to dismiss might not have been heard by Judge A, but the motion for summary judgment by Judge B. Judge B would have no previous knowledge of the case, but would have to review the pleadings and other papers before or during the hearing to familiarize herself with the suit. When the case reached trial, it might be tried before Judge C, who was assigned to the civil jury session at the time the case reached the trial list. By contrast, in federal court, the same judge will preside over the suit from the outset and will develop a feel for for the case through hearings and motions, discovery, conferences, and other pretrial proceedings. As Chapter 35 indicates, see info page 649, knowing which judge will preside over the case can have an important effect on the attorney's tactical decision. So, wow, I have really no idea about that this was the case, that you didn't necessarily know who was going to hear your case. Responding to the complaint. Once the defendant or her counsel receives the complaint, she must respond. In most cases, the defendant will answer the complaint. If the defendant has certain preliminary objections to the suit. However, she may move to dismiss instead. See the motion to dismiss for lack of personal jurisdiction filed by Jones, the third party defendant in the Schulansky case, in page 633. Defendant, Chapter 18 reviews in detail the circumstances in which a motion to dismiss may be filed instead of an answer. It is important to understand the difference between a pleading and a motion. A motion is not a pleading. See Federal Rules of Civil Procedure 7A and B, which provide separately for pleadings and motions. The pleadings set forth the position of the parties on a claim. A motion, by contrast, is a direct application of the court for an order. The pleading set forth the position of the parties in the claim. A motion, by contrast, is a direct application to the court for an order. Whenever a party seeks action from the court, a motion is an appropriate way to do so. So the pleading just says, this is my complaint. But the motion asks the court to do something about the complaint. Whenever a party seeks action from the court, a motion is an appropriate way to do so. For example, a defendant's motion to dismiss for lack of personal jurisdiction is a direct request to the court to dismiss the case. Although many types of motions are specifically provided for in the rules, see Federal Rules of Civil Procedure 12B, Section E, and 56, the motion is a flexible device for seeking any type of action from the court. One common examples of motions for further discovery motions to place a case on the trial list, to convene a discovery contest, to implead a third party, to amend the complaint to answer, to extend the time to answer, or for any other assistance in the litigation process. One well-known pro se litigant in Massachusetts is rumored to have filed a motion for a landmark decision. If the defendant answers the complaint instead of moving to dismiss, her answer must set forth her position on the allegations in the complaint. As Chapter 30 demonstrates, the Federal Rules of Civil Procedure require the plaintiff in federal suit to set forth her allegations in numbered paragraphs. The defendant's answer must respond to each allegation, paragraph by paragraph. The defendant must also assert defenses or counterclaims in the answer, as Ronan has done. The answer usually must be filed with the court and served to the plaintiff. The rules require the answer to motion to dismiss be filed within 20 days. But extensions to time to answer are frequently granted, often with the consent of the opposing party. Okay, now let's talk about discovery. Once the pleadings are complete, the case will move into the discovery phase. Discovery is the process by which the parties obtain information from each other and outside witnesses through several common sense devices authorized by the Rules of Procedure. In federal courts, 4 primary discovery devices are used to develop factual evidence in preparation for trial. Okay, and these are interrogatories authorized by Federal Rules of Civil Procedure 33 are written questions sent by one party to another, which must be answered under oath. Requests for production of documents under Federal Rules of Civil Procedure 34 are requests from a party for an opposing party to produce documents that may be relevant to the issues in the suit for inspection or copying by the requesting party. The third basic discovery tool is oral disposition authorized by Federal Civil Procedure 30. A disposition is the procedure for taking oral testimony from a witness. Fourth, the federal discovery rules require parties to make automatic disclosure of certain information regarding the case. In most federal court cases, the parties are now required to confer and plan for disclosures and discovery before they begin the discovery process. Federal Rules of Civil Procedure 2060 and up. Usually, counsel will take the disposition of crucial witnesses for the other party in order to prepare for trial and to get witness testimony on the record. The disposition is taken before a licensed court reporter, usually at the office of one of the party's attorneys. The witness testifies under oath and may be represented by counsel. Counsel for opposing parties are entitled to cross-examine, but usually do not do so extensively. Chapter 35 contains an excerpt from the plaintiff's disposition in the Shulansky case. Many cases involve complex technical issues, sophisticated reconstruction of accidents, complex statistical or economic projections, or specialized knowledge of medical procedures. In such cases, a crucial aspect of trial preparation is hiring and preparation of expert witnesses. Both sides will retain, often at considerable expense, recognized experts in the relevant dispute to testify on issues like causation, proper technique for industrial or medical procedures, accident reconstruction, or probable future damages. Both sides will seek discovery of the other side's experts. Much time will also be spent educating their own experts about the case, conducting experiments or calculations, and preparing them for direct and cross-examination. As with other aspects of life, the computer has changed the process of litigation. Lawyers now need a good deal of technical savvy and support to litigate effectively. Increasingly, parties employ sophisticated computer programs to store, organize, and retrieve litigation data and to develop effective courtroom presentations. An even greater impact of technology has been the change in the form of discoverable information. Some 90% of business documents now exist only in cyberspace. They are never printed out. R. Marcus and Reddish, E. Sherman Civil Procedure, A Modern Approach 377. Critical information may lurk on the backup disks, servers, hard drives, and metadata files and other newfangled and mysterious places. There is exponentially more information and more complexity in retrieving and protecting it. E-discovery is upon us whether we are ready for it or not. Despite the emphasis in this book on procedure rules and doctrines, the most crucial phase of a lawsuit is the development of evidence through the discovery process and investigation by the attorneys. Most cases are won, lost, or settled on the basis of the strength of the facts, and it is through discovery that the facts and the credibility of the crucial witnesses can be evaluated. Typically, the discovery phase will take at least a year in a reasonably substantial case, but it may take considerably longer. Attorney cooperation in the discovery process. Throughout this period, it is the attorneys who conduct the litigation by using the discovery tools provided in the rules, responding to discovery requests from the other side, and developing the evidence to support their cases at trial. In many cases, judicial involvement may be minimal right now to the time of trial. The attorneys carry the laboring oar by filing their pleadings, sending and responding to requests for discovery, scheduling and conducting depositions, meeting to discuss settlement, and where plausible, agreeing to stipulations of the undisputed facts to shorten the trial. Because discovery is conducted primarily by attorneys, it is important for opposing counsel to cooperate in the discovery process. The formality of the civil procedure rules and the adversary nature of litigation practice frequently lead beginning attorneys to conclude that they are not serving their clients unless they resist every request of opposing counsel. In the long run, however, unrestrained belligerence is counterproductive. It is entirely feasible for counsel to work together to facilitate moving a case to trial without in any way compromising their client's substantive rights. For example, many questions will arise during the pleadings and discovery phases of the suit that can be resolved by agreements of counsel. Extensions of time to file pleadings can be agreed to, saving the need to argue a contested motion for an extension. Stipulation of agreed facts can be drawn up to obviate the need to prove those facts at trial. Disagreements as to the scope or timing of discovery claims of attorney-client privilege or limits imposed by a preliminary injunction may often be worked out by counsel instead of taking court time. In addition, scheduling of deposition, and hearings on pretrial motions can be arranged with opposing counsel. In these and other ways, the process will run more smoothly and inexpensively for all concerned if the attorneys cooperate. The changing judicial role of litigation. Under the traditional model still followed to a degree in many state courts, the court itself plays a largely passive role in litigation. The parties file the pleadings, conduct discovery, initiate settlement discussions, and seek a trial when ready. Under this system, there is no active periodic judicial review of pending cases. For example, a judge will not review complaints as they are filed to determine whether the court has personal jurisdiction over the defendant or the Under the system, there is no active periodic judicial review of pending cases. For example, a judge will not review complaints as they are filed to determine whether the court has personal jurisdiction over the defendant or the complaint states the claim upon which relief can be granted. It is up to the attorney to raise such questions by filing an appropriate motion. The court is simply there to referee to respond to motions by the parties if the pleading or discovery process goes awry and to supply a judge to preside over the trial when and if a trial is necessary. If the attorneys choose to litigate at a leisurely pace, the court under this model does little to force them to try. However, the litigation process is moving away from this hands-off model as the volume of litigation increasingly strains court resources. Particularly in federal courts, judges are taking an activist role in managing cases by monitoring the discovery and disclosure process, limiting the issues in pretrial conferences, and setting deadlines for discovery and trial. For example, the court in federal cases is now required to enter a scheduling order in many cases, setting deadlines for the joinder of additional parties, amendment of pleadings, and completion of discovery. See Federal Rules of Civil Procedure 16b. The court may also schedule discovery conferences with the attorneys to monitor the progress of discovery, to narrow the issues, and to encourage settlement discussion. See Federal Rules of Civil Procedure 16a and c. Moving towards trial. As discussed in Chapter 22, lawsuits may be cut short by pretrial dismissal or summary judgment. However, most court cases survive these hurdles and, if not settled during the discovery phase, continue on track toward the culmination of the litigation process, a trial on merits. As the discovery process nears completion, the court will usually hold a pretrial conference to resolve pending motions, address evidentiary issues, encourage stipulations as to undisputed facts, determine the issues and witnesses for trial, explore the possibility of settlement, and set a final date for trial. See Federal Rules of Civil Procedure 16. In some systems, trials may be fairly prominent, but in others, the court's caseload forces long delays because the case is reached on the trial list. Such delays may lead counsel to agree to various alternative dispute resolution mechanisms, such as mediation, arbitration, or summary trial, to try to resolve the case without waiting for a formal trial. If parties persevere, they will eventually get a trial, but it is almost impossible in any system to predict or control exactly when that will be. Most cases, even if they are actively litigated through the discovery phase, are set down for trial and never tried. More than 90% of all civil actions are ultimately settled, many on the eve of trial. However, the considerable effort that goes into discovery and pretrial preparation in such cases is not wasted. It is the intensive development of the facts and the parties' increasingly sophisticated understanding of the strengths and weaknesses of their positions that make an equitable settlement possible. As trial approaches, settlement discussions become more focused, and parties usually begin to move toward an acceptable middle ground. In addition, the incentive to settle increases markedly as trial becomes an impending reality rather than a distant possibility. The attorney's experience of litigation. All of this is very well, but it still gives little impression as to what the experience of litigation is like for lawyers who conduct it. In practice, litigation is episodic, A lawyer may have anywhere from 20 to 50 or more active cases at a time at various stages, from pre-filing investigation to post-trial motions. At any given time, there will not be much happening in any of these cases. The lawyer might be awaiting response to discovery requests on one, awaiting judicial action on a motion to dismiss in another, discussing responses to interrogatories with her client in another, drafting an answer in another, awaiting a trial date in another, conducting settlement negotiations, and so on. Much of the average litigator's time is spent in detailed fact investigation, reviewing depositions and documents produced under discovery requests, interviewing witnesses, meeting with clients or experts, tracking down sources of proof, and preparing and organizing a testimony for trial. The work requires painstaking attention to detail. Oh, I'm not afraid of that. A good memory and a methodical approach to trial preparation helps. In addition, a good deal of time is spent drafting pleadings, motions, supporting affidavits, and other materials. There is frequently legal research to be done, especially by junior attorneys in the office. That part I love. And memoranda to be written in support or in opposition to pending motions. A litigator's case have a way of acting up unexpectedly. The morning mail or email may bring a motion for summary judgment in a case that has been sitting on the back burner, a motion for sanctions in a case based on allegedly inadequate response to a request for production of documents, notice of a deposition of an important witness, or an order from the court to appear for pretrial conference. The phone rings a lot, often with calls from opposing counsel or a frantic client. Often these litigation events require a proper response, a memorandum in opposition to a motion, an appearance in court to argue a motion, a conference with the client to draw up answers to interrogatories, or plan for a settlement conference, or preparation for an attendance at a deposition. Often during the process, the litigator must deal with others who are unhappy with her, opposing counsel who doesn't want to produce documents or schedule a disposition, a court clerk who refuses to change hearing date, a client who can't understand why everything takes so long, a colleague who needs a motion and memo right away. Stress levels rise. Diplomacy and patience, 2 courses not taught in law school, are much needed survival skills. Diplomacy and patience, 2 courses not taught. Okay, so that's good. Thus, a litigator is constantly juggling a number of cases, trying to keep all the balls in the air at once. The unexpected happens frequently, and a constant procession of deadlines back in. Occasionally, the process is punctuated by trials, which usually involve intensive periods of long hours and single-minded attention to one case, with constant with consequent reshuffling of commitments in other cases. However, for most litigators, trials are infrequent. Litigation practice resembles continuously preparing for exams, most of which are then called off at the last minute. Some lawyers find it exhilarating, others simply nerve-wracking, few find it dull. And that is chapter 29 and part 6, the rules in action, where we talk about an introduction to pretrial litigation, setting the stage for the Schulansky case. So we read that. Oh, now the Schulansky case. This whole time I've wondered, where's the Schulansky case? I think I read the wrong chapter. Okay, so that being the case, we are going to have to read the Schulansky case, and that is page 569 to page 587. Probably half here on today and then half tomorrow. Thank you again for tuning in to today's episode of Legally Raven Haired Law Office Study Program. Learn it like Lincoln at its finest. Bye.